This is The Right Approach. I'm J.W. Judge, and with me is my co-host Barbara Hinsky. This is a podcast for writers to learn more about the craft and business of writing as we explore a new topic every week. Our guest today is Jodé Millman, who will be talking with us about protecting your legal rights as an author. She has developed the Writers Law School, which is an educational program designed to inform writers and artists about protecting their artistic rights. And she is also the author of mystery novels that draw on her experiences as a lawyer and as a resident of Poughkeepsie, New York. So, Jodé, thank you for being with us today.
Thank you. Thank you for having me, Barbara and Jeremy. I appreciate it.
I have seen your name for so many years on things, so I feel like we got kind of like author royalty here. So I'm glad you're here.
Nice to be here.
And I feel like we should start with a disclaimer. So while we will be talking about legal rights, and while we are all three of us lawyers, we are not your lawyers. And so this is not legal advice. This is just a conversation about legal rights. So if you find yourself in need of a lawyer, you should hire one. But this is just a topic about legal rights and not legal advice. So that's all right. So let's start with you telling us where is the best place for us to start this conversation about an author's legal rights.
Well, I think we have to start with the basics, and the basics are always copyright law, because that is something that affects all writers. And we begin with opening the first page of your book, and you see your little copyright bug, your little C with your circle, the date, your name, and that represents that you acknowledge your rights and you know your rights in copyrights. And people always ask me, well, what is a copyright? What does it mean? What is it? Well, it represents like a whole package of rights. It's the right to duplicate. It's the right to display. It's the right to distribute. It's the right to create what's known as derivative works from the work that you've created under your initial copyright. And what makes you an author, and people don't really understand this, but from the moment you put your fingers on a keyboard, from the moment that you put your piece of paper on your desk and put a pen on it, you are an author. If you are the original creator of that work, you are an author and you're entitled to copyright protection under the law.
And I think there is a lot of confusion about that because people think they need to file something with the copyright, with the government to have copyright protection, but that isn't the case.
Well, the protection is not, in order to obtain the protection, you do not have to register with the Copyright Office. However, in order to exercise any rights, for example, let's say that your copyright is infringed, or if you really want to, I always tell people that they should register, but you cannot assert your rights unless you have that registration certificate. And it's really not an expensive process. It's not a prolonged process. You can do it in 15 minutes on the internet at www.copyright.gov. You get a nice little certificate, and that in itself creates your ability to, as I said, litigate in federal court, to use the copyright offices. They've got a small claims procedure. It also entitles you to more damages than you would get, reimbursement of attorney's fees and expenses and interest. So it does have its advantages at the cost of $45.
Well, and it also, don't you think it has a little bit of a prophylactic effect? I mean, even as a practical matter, if you don't want to sue somebody, even if you don't want to do all that,
right,
it maybe chases some of the bad actors away from your door because you do not look like low-hanging fruit. If you've got
I agree. Yeah, I agree. It shows the world that you know what your rights are. And again, if you have this registration and certificate, it's legal evidence, it's prima facie evidence that you are the owner of this particular work. So there are no challenges whatsoever to your ownership in a book or a story or photograph or a painting. So it's really a worthwhile protection that's extremely affordable.
Yes.
So for folks who write under a pen name, like I do, like Barb does, how, if at all, does that affect their copyright protection?
It doesn't, because the form itself asks if you write under a pen name. So it would be, you'd have both names on that application to the Copyright Office. And I always tell people to apply to the online, because it takes almost 12 months for you to get the certificate back from the federal government, because just the way the government operates. So if you do it online and you print out your receipt, you've got, your automatic receipt there to show that you're the owner and that you filed. That's what I always tell people. You can do snail mail, but it's more difficult to keep track of. And what's interesting is that you think it's a big agency, and that if there are any questions, you'll get lost. I can tell you from personal experience that I've been in dialogues with members of the Copyright Office. For the last book that I did, The Empty Kayak, when I submitted my copyright application, I tried to copyright the cover of the book, the artwork. And on the form, it indicated who was the author. I said myself, and I'd also used a program called DALL-E, which is an offshoot of ChatGPT. It's an artificial intelligence program where you put in a narrative and it pops up with artwork. So I used that program in order to create my art, my cover. And in order to use that program, you have to acknowledge DALL-E on your title page of your book or wherever you use it. So I put it on the copyright form that I had used this program, and I got a letter from the Copyright Office saying, "Hey, Jodé, how much of the cover was created by artificial intelligence?" And I said, "Well, the artwork was." And they said, "Well, guess what? It was not created by a human, so it's not subject to copyright protection. Only products that are created by human beings are subject to copyright protection." So I had to revise my application and withdraw any coverage for my cover. So they do speak to you. I mean, if they have questions about your application, they will be in contact with you. But that's also a lesson about artificial intelligence.
Yeah, I was going to say, and that also needs to be, for folks who consider using Chat GPT or, other programs that are derived from it for part of your writing process, you need to be fully aware of the effect that could have, that if, the Copyright Office determines that, AI had a hand in creating this and therefore it isn't copyrightable, then you may not have the protections that a person who completely drafted their own work would have.
Well, the Copyright Office right now is really entering the Wild West. There have been a few cases that have come down regarding artificial intelligence. And as I said, the bottom line is that if it's not created by a human, it's not entitled to protection. However, there's a line between artificially intelligence created and generated versus artificially intelligence assisted. So let's say you're working on a book and you're using Grammarly, or you're using Pro Writing, or you're using any kind of program that helps you. That's okay, as long as it's the helper. It's not the creator. It's not the Chat GPT that's spitting out your narrative and your work. In that instance, if it's generated, it will not be. And they require you on the application to indicate whether or not you have been assisted or it's been generated by artificial intelligence. It's like I said, it's the Wild West, and every day the law is changing on that topic.
Yeah, I want to ask, just backing up on copyright a little bit, because I have someone I mentor who's written a children's book, which is not my ideal, but anyway, the copyright, she says the Copyright Office insisted she get a separate copyright for her ebook and her print book.
Well, that doesn't make any sense to me.
It doesn't make any sense because it's the content versus the format.
Right.
So I thought there's got to be something misunderstood in that. Okay.
Yeah. I could see it where the text and the artwork could be covered by different copyrights, but not the format. I'm surprised to hear that, quite honestly.
You know what? That must be what she's misunderstanding. I hadn't thought about that, but that's probably what it is.
Hmm.
And her husband did the artwork, so,
Oh,
which is
so
great. But
that's
anyway,
it.
yeah,
That's your answer right there. Yeah.
yeah, good.
Well, I noticed when I loaded onto Amazon, my or KDP, my book Watch Party was coming out in April. That this time I had to affirm whether or not
Yes.
AI had contributed in both the content of the book and the creation of the cover. I think because I think I had to do it in both. But that was new. That was something to be mindful of. It's not just the copyright office who wants to know about these things. It's certainly Amazon. I haven't done draft to digital recently or any of the others that are the aggregators like that, but I expect they want to know this information. And something I think we should also be aware of is it's not only the United States Copyright Office that's wrangling with all these changes and trying to figure out, you know, what they're going to do. Each other country is also handling these issues, and everybody is not going to land exactly the same on what to do with them. And so authors need to be mindful of just because, if you use AI in some format, just because you're protected in the United States, you might not receive the same protections somewhere else. So that's just, something that occurred to me as we were talking to be aware of.
Well, the European Union is the first group in the world that it's ready to sign legislation pertaining to artificial intelligence. So, if you're going to be publishing a book in England or Germany or Spain, you're going to be covered by that particular statute. China has permitted the copyright registration for AI generated material. So if you're publishing in China, it's a different story. And like you said, here we're subject to the laws of the United States. So it's going to be different than those other jurisdictions. So you're absolutely right. You have to see where you're publishing.
So moving away from copyright to trademark, how does how do trademark rights affect authors?
Well, what can I jump back a second
Yes.
to one issue on copyright that's really important, and that's public domain. And public domain means that after a period of time, the copyrights expire. Copyrights last for the life of the author plus 70 years. But prior to 1978, there was another law which allowed a specific period of time and extensions on copyrights. And we're finding now, for example, that any work that was created before 1927 is now in the public domain. So what that means is that if you wanted to borrow a work from the public domain, or you wanted to reprint the work, or you wanted to take the characters, you're free to do that. Now, why is that a big issue? Because this year, Steamboat Willie, who is the great grandfather of Mickey Mouse, entered the public domain. That movie entered the public domain. So what does that mean? That means that if you wanted to go ahead and produce anything that looked like Steamboat Willie or Steamboat Minnie, you wanted to do any stories involving those characters, or you wanted to go ahead and just, copy that, you would be entitled to do that. However, this segues into trademark. There are issues that are related to the public domain and trademark. And just look at Mickey Mouse. Mickey Mouse has had millions of iterations from his inception in 1927 to today. So you have Disney that's got copyrights and trademarks on the more recent work, as opposed to the Steamboat Willie, who's in the public domain. So you have to be very careful if you're using a well-known figure like that. Bambi's another one that's in the public domain. Winnie the Pooh is in the public domain. You have to be very careful not to mislead people that you are the Disney, of the public domain. You can't use their images. You can use the original images. So there's a tension between the trademark law, which protects the flow of goods in commerce. Like I said, you could think of Mickey Mouse, or for example, think about VW or Oreo cookies or Pop-Tarts. Those are goods that are in commerce. Those are things we go into the store, we buy, you recognize the box. That's consumer oriented, where copyright is artistically oriented. So you have here in the present law, you've got a contrast between an attention between copyright and trademark. I hope that answers your question.
No, I think that's a great segue.
Yeah,
And one thing
and
I would,
jump in and ask something
Sure.
about that. Just that, so song lyrics. I like to quote song lyrics, and I found that I do it before 1927 because I don't want to get into how much, but that's the same kind of thing. You got to go back and
Same
use
kind of thing. And
yourself
people
an
ask
old
me that
song.
all the time. Can I quote a musical lyric? The answer is no, 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 no,
Yeah,
unless it's in the public domain, because you have to get permission. And people say, well, suppose I only use like 4 or 5 words. No,
not if they're
it's not in the
distinctive.
public
Yeah,
domain. It's licensed by McCartney and Lennon. You have to get their
yeah.
permission. Same thing with poetry. People ask me about poetry all the time. No, you cannot do it unless it's in the public domain, or you want to spend the money to get the licensing rights.
No,
And nobody
all
wants
those
to do that.
people are way richer than, do I want to tangle with Disney? No, thank you.
Exactly.
Yeah. Go ahead, Jeremy. Sorry.
I was going to say one thing I wanted to mention as far as copyright and what exists after your death is the interview that we did with Michael Laron last year, where he has written a couple of books about protecting your rights and author estates and that sort of thing. That's definitely a worthwhile listen. That kind of piggybacks on the topic here. So I know that Jodé, that there are limitations about what trademarks authors can register, like things they can and can't. Like you can't register the title of a book as a trademark, but if you have, characters like Harry Potter or the name of a series, there are things that you can register and protect those. And that may not be significant for most of us because, we aren't George Lucas, who's going to create Luke Skywalker and Darth Vader and characters that go on to live for, 70 plus years and be in the, zeitgeist of pop culture.
Yeah.
But if lightning strikes, you need to know what you can and can't do. So, what can authors do and not do?
Well, as far as trademarks, as I said, they protect logos. They also protect, for example, if you think about FedEx and Google, they provide services. So if you are a service provider, let's say that you're a writers organization, that is something that's protectable by trademark. Now, as you mentioned, Jerry, the title of a book is not subject to trademark protection. However, a series is. So if you think about the Twilight Saga, that is subject to trademark protection. The Outlander series, the Dune series, anything that's a series is subject to protection, but not the books, not the individual titles themselves. Another thing which is really isn't relevant to this conversation, but fashion, certain costumes are protected by trademark. So let's go back to George Lucas and Princess Leia. Technically, her garb is subject to protection under trademark, as would be if you went to a Broadway show. Any of those are. So I think those are the basic guidelines. The basic guidelines is not the title of your book, just the series of your book and your characters, of course.
What about, I know, there are a lot of indie authors like me who create a publishing imprint. And I went ahead when I was deciding on a name, I went to the patent and trademark office and their website and looked up a bunch of the names that I was considering operating under as my publishing imprint and found that a lot of them were taken. And so I kept going down the list until I found one that wasn't. And even when I landed on Scarlet Oak Press, which is what I use, I had, it wasn't there, but I also wanted to make sure it wasn't in use, but not registered. And so that's where I landed on. That's where I registered as a trademark. Um, and so what is the value for when you have things that you can register as a trademark? What is the benefit of doing so?
Well, let me give you a little bit of a hack. When you go to the federal government to register a trademark, it's going to cost somewhere between around $500 in order for you to apply. Now, when you get their application, and you have, let's say you have a logo that you want to go ahead, JW Judge author, you just don't send them in your logo. It's a very specific kind of a grid that it's for example, certain colors are certain hashes and symbols. So again, you're getting into very complicated waters when you apply for a trademark. However, most states allow you to trademark your logo, your name, your series in their Secretary of State offices. So instead of spending $500 with the federal government, you can go to your Secretary of State, do it online, and maybe pay $50. So my suggestion to people always is just go on the state level, unless you're like, a J.K. Rowling and you're creating a Harry Potter, go ahead, do it on the local level. It's going to give you the same level of protection. And if necessary, you could always, let's say I live in New York and I, go to events in Connecticut. I do New York and Connecticut. It's a simple hack. It's an easy procedure, and it gives me the protection and the writers the protection that they need.
I wanted to ask you, that's a great hack. I hadn't thought about that. Ask you a little bit about pirated works, because I think anybody who's been published for very long will find their works on some other site. And in the early days, I would send them the takedown notice and all that kind of stuff. And it just became whack-a-mole. And how do you know if anybody really is doing it? So I just ignore it, which maybe isn't the best thing to do. But what do you tell people? I know there are services that you can engage in that are very expensive. I don't know. What do you think?
I think it's time consuming. There's the Millennium Digital Management Act, which allows you to send notices as you've done takedown notices. There's also a very complicated procedure for locating. You have to locate the IP address if it's online. I mean, there's like this whole complicated procedure.
Yeah.
Fortunately, I've never done it. And I've never had any reason to do it. However, so I really don't have an answer about that. However, there is a mining I think it really segue into the mining that's going on right now by the artificial intelligence companies. Because how do you think they're training their algorithms? They're going to pirated sites. They're going to Google. They're going to, they're just mining millions and billions of bits of information, which may include your work and my work.
Yeah.
Now there's a website, Have I Been Scanned or something like that, or I forget the name of it off the top of my head. There's a website where you can go and put your name in and put your work in, and it'll tell you whether or not you've been harvested. Have I been harvested?
Yeah.
So, and then again, once you find that out, there's another long procedure for notifying them to tell them not to use your product, not to use your words. What I'm telling people today is that on their title page, put a notice that, you're clearly stating that your book is for publication only. It's not for use in training any type of artificial intelligence. Put that language on your title page, in the back right where the copyright is, so that you're putting them on notice that they should not harvest you for algorithm purposes. But, it depends how much time you want to spend chasing down the pirates, whether it's ChatGPT or whether it's, the dark web. Is it worth it?
Yeah.
Well, as a practical matter, what recourse is there that's available?
Litigation. It all comes down to litigation. And again, one of the great things that the Copyright Office did during the pandemic was they included a small claims court in their new new statute. And what it is, it's created a tribunal so that people can now, if you've got royalties or you have damages less than $15,000, you're entitled to apply to this tribunal, send in your information, only pay $40 to them. They'll analyze the case, determine whether or not you have a case and should go forward. Then when they notify you, you send in another $60 and they will go ahead and proceed on your behalf. So that's a great way to go against an infringer on a very cost-minded basis, and a very easy way to do it. And again, if you go to copyright.gov and you type in Copyright Tribunal, all the information's right there. It's very easy.
That's really helpful. And that it's a really reasonable filing fee. I mean, I know
Yes.
that if you file in any state court, it's going to be a couple $100s at minimum. So that's very efficient.
Very efficient. And
And
I
one
hear the time, they turn them around in a couple months too. It's not prolonged litigation like, we're all used to in the court system.
I mean, one thing I know that somebody's been pirated if I'll get a 1-star review on one of my old series and they talk about it's full of typos, it's full of errors, there are missing sentences. Okay, hello, you bought a pirated copy from somewhere. And,
Right.
So I'll just contact Amazon and then they'll take it down.
Right.
That's the most I'm willing to do with it.
It's part of what we live with as writers.
Yes. Yeah.
Well, for folks who are listening to this and thinking, all right, this has been a really helpful overview, but I need more. Where
Yes.
can they go to find more from you, Jodé? I know at the top we mentioned your Writers Law School. I know you do speaking on this. So where can people go to find more about you and the work that you do, courses you offer to get educated on this stuff?
Well, the best thing to do is probably to go to my website, which is www.jodymillman.com, because if there's a link under blog, and that's all my Writers Law School information, which includes blogs that I've written over the years about, specific topics that we've kind of touched on today. Also, where I will be presenting my Writers Law School. Right now, I'm in the process I've created a new program about artificial intelligence called Writers and AI, the robots are coming. And for example, on March 2nd, I'm going to be giving it at the Grand Canyon Writers, Sisters in Crime. So if people are members, they can sign on there. And my schedule will be listed, on my website. So that's probably the place to go.
Would you spell your names so people have it right? Yeah.
It's JODEMILLMAN.com.
Yeah.
Or they
thank
could
you so
Google
much.
Writers Law School, it'll pop up too. So
Okay, perfect. Well, this has been a really good overview. It's been really helpful. Kind of a refresher course for folks who are familiar with it. And so thank you so much for your time and for sharing that with us.
And just
thank you. It's great to be here. I enjoyed speaking with you guys.
Thank you. And thanks for all you do for writers to help keep us safe. It's such a hard job. We work so hard. We deserve to keep the few little shekels we make from our work.
That's true.